Again, appreciate everyone getting on today. My name is Danny Fitzgerald. I'm the Acting Regional Director for the San Diego and Imperial Small Business Development Center Network. We are chartered by the U.S. Small Business Administration and funded by them, as well as the state of California's Office of Business and Economic Development. And we have a wonderful guest speaker today. So, of course, as the SBDC, we assist a number of different businesses with everything. We've been doing a ton of work, of course, during the COVID-19 around disaster capital, disaster issues. And now certainly as we're, as our economy has changed and we're reopening, we have our Adapt series and all sorts of different things, everything from HR issues to how to set up an outdoor dining experience. And today we have a fantastic guest with Tom Turner with CBRE to talk about something that is really unique, because as our workspaces change, obviously we're going to have to look at things from a commercial leasing situation. And so we have Tom here today to be able to kind of talk about that, and to be able to kind of talk about ways in which we can do, you can do different types of renegotiations of your commercial lease, some of those structures. For kind of logistics for the day, so it's best if you put your question in the chat box. That's how we'll be answering the questions. We'll have two Q&A times, one obviously at the end of the presentation, but there is one kind of in the middle before Tom gets into kind of some of the tactics of the renegotiation, kind of the more general aspects of commercial leases that he'll be able to do. So let me get our PowerPoint on up, and we'll turn it over to Tom.
Great, thanks very much, Dan. Welcome, everybody. Why don't we go ahead, Danny, to the next slide, if you will.
All right, it's doing a weird share for me. So there we go. Let me get this sharing correctly.
There, I thought it would be worthwhile. First, greetings, everyone. I'm coming to you from my home office. I'm guessing there's a lot of you in your own home offices here today as well. I hope you're doing well through these challenging times. I thought it'd be helpful to give you a little bit of a background about myself, because it's uniquely pertinent to what we're going to talk about today. I had a whole career as a commercial real estate lawyer before going into brokerage. So I was at UCLA undergrad and went to UC Berkeley Law School, and then worked as a commercial real estate lawyer for over 30 years, so representing both landlords and tenants. So importantly, I got a lot of experience from both sides of the table there. I was, fortunate enough to be recognized with all the big awards, best, San Diego lawyers and best lawyers in America and all that stuff. So I feel like I've mastered that craft well, but I always found in working on those deals that it was really the deal part that was more interesting to me, the business aspects. And I got a lot of kicks out of cutting the best business deals I could in addition to doing kind of the fine-tuned legal work. I then had a bit of a career within a career, because I was the managing partner of what became, while I was in charge, the largest San Diego-based law firm. So I was the principal in the deal. I was the business person striking the arrangements, and really gained a different perspective there of making the business decisions, putting together the brokerage team, the design team, construction team, and going all the way through the build out to a fully operational setup. And was able then to really kind of solidify the fact that that's really where I got the most satisfaction out of my career. And so when the opportunity arose to break out into the commercial real estate brokerage side, I did just that. And now I'm with CBRE. It's actually the largest commercial real estate brokerage firm in the world. And I've been representing tenants. So representing all kinds of businesses, large and small, in negotiating, finding great space and negotiating great deals in it. So one of the beauties of that is the way that the industry standard is set up. My clients don't have to pay me. It's a pretty unique scenario, because the landlords are the ones that pay the tenants brokerage fees. So basically, you can hire the best out there and have the best working for you, and have the landlord pick up the tab. So it's kind of a helpful structure there. Let's pop ahead, Danny, to the overview of what we're looking at here. Everybody's got a different perspective on this, but basically, we're looking at unprecedented times. It's been said that at times there's very little fundamental structural economic change in our society over long periods of time, over decades. But then sometimes in one decade or one year, there's a decade worth of changes. we have just kind of taken that to a whole new level at this stage with this whole COVID situation, where over the last 3 or 4 months, we've had multiple decades worth of true fundamental structural economic changes that we all have to deal with. So basically the overview is that it's just kind of a mess right now. COVID has affected every business in one way or another, some many more, much worse than others in many different ways. Very disparate impacts for different types of businesses. Retailers have been struck among the worst, although that's primarily the brick and mortar retailers. We've got groups like Amazon that are absolutely thriving and picking up as much real estate as they can, hiring as fast as they can. You've got logistics companies, grocery stores, data centers that are thriving. We've got an awful lot of people that are really, really hurting. And we thought this might pass relatively quickly, but it's going on and on. You're probably aware of the legislation that's been passed to preclude evictions for now, but it's important to recognize that that does not in any way prevent the rent from building up. And so in a way, it's kind of postponing the inevitable. The work from home policies have changed everything, and we're still evaluating how that's going to look when we reach the new normal. But it's clear that we've got an unprecedented level of unemployment, over 40 million. And what we're really looking at today is, if you kind of look at the handshake icon, we're looking at trying to come to a mutually agreeable arrangement between a landlord and a tenant to restructure the lease in a way that will be satisfactory to both sides, but importantly, provide short-term economic relief for tenants where they just have a huge gap in their revenue stream currently. Sounds like it shouldn't be that hard, but it's almost always at least a three-party process. We'll talk about how often there'll be more parties than that entailed. Often, one of those parties is a commercial real estate lender, and those folks are notoriously risk averse, and now maybe more so than ever because there's so much uncertainty out there. And that's something that lenders really don't like. So we thought that this might be a relatively brief multiple month period phenomenon. It looks like it's going to be a long road. It makes me think of the Winston Churchill quote that it's not the beginning of the end, but it is perhaps the end of the beginning. So we got a long road ahead of us still. Let's move ahead, Dan, if you will. I've made this similar presentation to this to a number of law groups, different bar associations and so forth, and those lawyers are quick to jump to the question about whether there's usually a contractual basis to avoid paying rent. And there's all sorts of different legal theories that could support that, something called force majeure or acts of nature, acts of God that preclude the ability to perform a contract. People can argue that they don't have access to their premises, so they shouldn't have to pay rent, that they aren't being provided the essential services that their landlord is required to provide, or that because this is based on a governmental intervention that they shouldn't be required to pay. Interestingly, we haven't seen anybody really have any success with any of those legal theories. The closest we've seen come to a benefit for tenants is something called commercial frustration. It's a common law theory that is based on the fact that if you really don't get the benefit of what you've bargained for under a contract, that even though you have a binding contract, you don't have to perform your side of it. Again, it's come the closest to being a sound argument, but frankly, we've seen a real lack of success with the legal arguments. So what we're looking to is to go really beyond that. And if you move forward, Danny, please, we're looking to go really beyond the contract and look at the components of what really is needed to come to a mutually agreeable arrangement, because you can't rely on a legal argument. You need to come up with a voluntary and mutually agreeable arrangement. So communication is absolutely key. You can't hide your head in the sand on this, but you need, if you're a tenant, to reach out and ideally be proactive with landlords. And we focus on reasonableness. I think an awful lot of folks have hoped that there would be an aura of sympathy, that in light of the extremity of this situation, that landlords would be empathetic, sympathetic, and just provide them some relief. It's It happens, but it's very rare. We'll talk about that as one of the very rare scenarios. But really what you need to do is to provide some kind of what the legal and Latin terminology is the quid pro quo. You have to provide something in exchange for getting relief, and you have to provide an arrangement that is reasonable from both sides of the table. We talked about that there's legislation to eliminate evictions, but again, that doesn't mean the rent stops accruing. And so it really can just kind of fester and create a bigger and bigger problem. There was legislation pending in the California legislature that would have really allowed for tenants to require a restructure, Senate Bill 939, but that died in committee and is not going anywhere. So I don't think we can look for help there. So one thing that is important to take a look at, and I encourage you to do it if you're a tenant and you have not done so, is to look at your business interruption insurance and your commercial liability policy. There's all sorts of different shapes and sizes of business interruption insurance, but indeed, some folks have had some luck with that, and you're going to find that a lot of landlords are going to want you to pursue that as a first avenue before you approach them. So again, in terms of your overall approach here, the keys are being open and transparent and communicative with the landlord, and also being fair, not trying to weight it too heavily on your side, but make it an arrangement that the landlord can live with and feel like they're getting something out of the deal as well. Let's move forward, please. Here we're going to get into the, if we can, we're going to get into the fundamental varieties of structures for postponing or forgiving rent here. And there's a variety that we've itemized here, and I'll go through in detail with each of them, but you should know that there's also all sorts of different variations on the theme. And what often happens is there's combinations of these different components that end up resulting in a successful renegotiation of a lease. The simplest and obviously most favorable for the tenant is simply the landlord decides to forgive rent. Whenever we talk in the context of rent forgiveness, it's important to note that it need not be full months of rent that are considered here, but partial months of rent. It could be half months, it could be quarter months, it could be 75%. There's no magic number there. So you can mix and match to kind of create your own formula. This obviously is the one that tenants would love to have all the time, and it's the rarest one. We've seen it come up where landlords, particularly in high-risk retail business situations, have offered to provide rent relief and just said, hey, this is such a tough time, I'm going to give you a couple months free to help you get back on your feet. And one of the reasons that landlords do that, frankly, there maybe is a certain amount of altruism, but there also can be a self-serving aspect of that. If a landlord, say, of a retail strip mall has a number of tenants that are on the ropes, it's not going to do the landlord any good to be really hard-nosed and have a whole slew of those tenants go out of business. And by the time that the COVID situation passes us, the landlord's got an empty strip mall on their hands. So it does happen, but in fact, it's definitely a rarity. More often what we're seeing is some variation of rent deferral. And that basically is a situation where the tenant may get 2 or 3 or 4 months of no rent at this point, or again, it could be partial rent deferral up front on a current basis when the income stream is broken up, as we have an awful lot of folks dealing with now, in exchange for extending the term that same number of months. So at the back end of the lease term, it would just, the lease would continue for as many months as the rent was forgiven for. A couple of key questions there is really what that term is, what that deferral is, and how soon you have to repay that rent. If the rent is forgiven for several months, but you need to pay it back in, a lot of people in April said, hey, I'll pay it back by the end of the year. And here we're in July and there's no sign of this thing letting up. That again is a situation where you can be looking at kind of foregoing the inevitable and just kind of deferring destiny of needing to default. So more often tenants have agreed to repay the rent through the end of 2021, or better yet, have come to a mutual agreement with the landlord where the rent would be spread out over the entire balance of the lease term. So that may be 3 or 4 years, depending on your circumstance, and the tenant would be paying basically a prorated monthly amount throughout that period of time. Question then is begged, whether the landlord charges interest on that. Theoretically, they could, because of the time value of money. As a practical matter, the outcomes we've most often seen is that the landlords find a spark of good in their heart in that situation, at least don't charge interest for it, but do require repayment. Keep in mind that whenever you're having one of these arrangements where the landlord is forgiving rent or deferring rent, it's almost always going to be some sort of a conditional forgiveness. So the landlord will say, okay, I'll give you a couple of months free, but only if you perform for the balance of your lease term. I'm not going to give you a couple free months rent and then have you default after that. That forgiveness of rent is going to be conditioned on your performance by paying rent throughout the remainder of the term. And if you don't do that, then that rent obligation would kick back in. So again, there's the month-for-month deferral, and that is a favorable one actually for a tenant where they don't have to pay rent for 2 or 3 or 4 months now. The lease gets extended, the term gets extended for 2 or 3 or 4 months at the back end. Typically there's annual increases in rent, so the landlord will get a little bit a higher monthly rent there. But all in all, that's still a very favorable arrangement for the tenant in that they're essentially getting a twofer. If they get a month free now and they have to pay a month at the end, they're still only paying for 1 month, even if it may be at a slightly higher rate, and getting 2 months of occupancy. So that's a great arrangement if you can come up with it, if you can get the landlord to agree. More often than that, you see what's commonly referred to informally as a blend and extend. And that's where the tenant receives several months of free rent, or again, partial free rent, and they add at the end of the lease term proportionally longer terms. So for instance, if they are forgiven or postpone 1 month's rent, they may be required to add 3 months to the end of the lease term. Some landlords are requiring more than that, 6 months. There's no magic numbers here. It all depends on what you can come to terms with on a mutually agreeable arrangement with the landlord. But that's an arrangement that has received a good deal of attention and success, the blend and extend, where for a relatively short deferral of rent, the tenant agrees to extend the lease for a longer period of time than that. Another thing that we've seen work where a tenant is very comfortable in their space and is comfortable that they're going to be happy there for a period of time beyond the current lease term. And a lot of tenants have renewal option built into their lease. And that's just to go ahead and do a full extension. It might be a 5-year extension, is fairly typical. And what often happens at the beginning of a 5-year lease term, if it's a new tenancy, is that the arrangement will be that there'll be some free rent up front, that in a 5-year term, you might get 3 months of free rent at the front end of that usually would go towards technology or moving expenses or something like that in connection with moving into a space. But in this case, could be used to basically just to accommodate for the lack of income flow. But it would then again commit the tenant to the full additional term, be that 3, 5 years, or whatever. But it's an arrangement that has worked very successfully. Again, you obviously have to be comfortable with that you're going to be happy in that space for the long run in order to cut that deal. But there again, you're providing something meaningful to the landlord in exchange for their forgiveness of your rent or deferral of your rent. Another arrangement that the landlords often favor, it's for accounting reasons that I'll get into in a bit, is instead of forgiving rent, they actually kind of work around that by applying your security deposit under your lease, which is typically a month or 2 months rent, and putting that money in their pocket, taking it out of the kind of separate account that they have that set aside in, and having you refurbish the security deposit. It's the same economics as paying rent, but it's more favorable for the landlord economically. So there may be concessions that the landlord is willing to provide in exchange for that. I thought it'd be good. This is Danny mentioned. We'd have a little break in the middle here to address questions. I thought since we've just gone through some of the fundamental structures, it might be a good time to open it up for any questions that you may have. Do you have anything coming in, Danny, on the chat box?
We have one. So one said that her property management firm sent them a letter that they need to shut down due to a governor's directive. Is that a government action or a property management action? And then if they're sending the letter, does that mean her rent is still due?
So the answer to that is, well, this is a classic lawyer's answer. It depends. If it really was dictated by the government, then indeed that's government directed. But unfortunately, as I referenced at the outset, under the terms of almost all commercial leases, unless you've got a really extraordinary force majeure provision, that does not preclude rent from being due. In fact, most force majeure provisions actually expressly state that this does not provide for the forgiveness of rent. So that kind of legal argument we've found is often made, but is very, very seldom successful. And the successful approaches are ones where you, again, negotiate a mutually agreeable arrangement with the landlord.
Okay. So the next one, and I think this is probably what you're going to do in your next section, but is can you talk to best approaches for restaurateurs to take with respect to renegotiations in light of past and future shutdown orders?
Yeah, that it really applies. Was that Chris Kramer from Carl Strauss?
It's Chris Kramer, so that
if so, hi Chris. At any rate, yeah.
How's it going, Tom?
Nice to hear from you, Chris.
Good to see you. You're doing great, man. Keep it going.
Thank you. With respect to restaurants, the business situation is extreme now, but the considerations are really the same as for industrial, commercial, retail leases in terms of all these various factors that go into play, and we'll be walking through those in the coming slides.
and
Go ahead, Danny.
And then the next one here that we have is, and I think you're going to talk about this, so suggestions for getting out of a commercial lease early.
So again, that goes back to a negotiated resolution. There's really no legal basis to do that. There's no contractual basis to do that, but you would have to provide some sort of a concession to the landlord typically, and that would be basically a termination agreement as opposed to a renegotiation. And typically the landlord would require a significant fee for that. So what we're mostly looking at here is not just nobody, when they have a break in the revenue stream, wants to write the landlord a big extra check. So we're really looking at means of finding creative solutions that allow for a temporary forgiveness or deferral of rent in exchange for something else along the lines of these extension, blend and extend, early extension of lease, that kind of a thing. So let's look at some of the related. Oh, do you have another question, Danny?
We do, and then I have one that's been posed by a lot of clients that I want to ask you.
Sure.
And so I'll actually ask mine first, and then we'll get to this next one. So because I noticed you talked about business interruption insurance a little bit. I know that a lot of pretty much almost everybody found that their business interruption had the joyous virus exclusion. What are you seeing in terms of that? Well, when those would apply or not, or things like that. So
If your old business interruption insurance doesn't have a virus exception, you can almost take it to the bank that your new one that next time around will. The insurers are pretty famous for making adjustments as circumstances come up. Indeed, if they do have a virus extension, it's a contract. The terms of that contract are almost always binding. So I don't want to get everybody's hopes up, but we have found numerous cases where there's business interruption insurance without that exception. So it certainly is worth checking with your broker or your risk management person to examine whether your policy would cover that.
And then the last one we got here in the chat is paying only a percentage of the rent reasonable when the business has been dramatically reduced?
I think it's absolutely reasonable. The question is whether the landlord will agree that it's reasonable, because it makes a host of sense from the tenant side. But again, the landlord isn't obligated to agree to that. If the landlord has some compassion, they may do it out of the goodness of their heart. But typically, you have to provide, again, that quid pro quo, that's something in exchange for that, whether that's an extension of the lease term, or an increase in the rent later in time, or again, a repayment of the forgiven portion of the rent over a period of time. Again, tenants would love to get something for nothing, but the landlords need to agree in order to make this thing work.
Awesome. All right, we'll get you moved on to the next slide here.
Okay. There's a lot of different angles on this. I mentioned the accounting aspects with respect to the burn down of the security deposit. That situation is a little bit unique in that the security deposit shows up on the landlord's balance sheet as a liability. And so they just kind of add on to that when they forgive rent. So the structure from the landlord's perspective is beneficial because they apply the security deposit and pay themselves that. You refurbish the security deposit, so it's a net neutral. It's kind of a net zero on the landlord's books. That may not seem like a very meaningful impact for one tenant, 1 month's rent. But if you've got an institutional landlord that's got a big office complex, or a retail operator with a huge shopping center, they've got 100 tenants, that kind of thing can add up. But the accounting ramifications always have to be taken into account from everybody's perspective. Be careful about the effect that it may have on you as a tenant. If in fact the landlord forgives the rent, you may be receiving cancellation of indebtedness income in exchange for that, or as an accounting ramification of that, that you could be responsible for income tax on. So you do have to consider the accounting aspects. Refurbishment is another one of the creative approaches that can be viewed here. When it's good to be creative and think outside the box about potential ways to resolve this. If, for instance, you're willing to extend your lease term, maybe it's a good time for you to look at what you might be able to do in exchange with the landlord. Say your carpet's getting long in the tooth, your paint needs some help. You need to rearrange a few walls within the premises to make it more operationally efficient for you. Now's a good time to just kind of put that in a package and say, okay, Mr. or Ms. Landlord, if you'll fund some additional tenant improvement cost for me now, we can build that into an overall resolution of this. And in exchange for that, I'll agree to a 3-year extension of my lease term. Kind of the flip side of that is a number of tenants are looking at the near future now, and they're thinking, gosh, I may have a little bit more space than I really need, and more space than is really optimum for me. If I've got 5,000 feet, maybe I could really operate perfectly well in 3,000 square feet. And so again, you can open up a whole wide open scenario of negotiating with the landlord about a new arrangement here. The idea is being creative here. So if you can say agree to a multiple year extension of your lease term, the landlord might agree to actually downsize your space to reduce your overall monthly nut. The landlord has that other space available to rent, and they've got you on the hook for a longer period of time in exchange for coming down to kind of what we think of as the right size, the appropriate size, which is usually the downsize. One thing that you should be aware of that is likely to be requested in this situation is, in almost all of these scenarios, we're asking the landlord to provide some inducement for us. They're going to be postponing rent. They're going to be forgiving rent. They're basically going to be putting themselves out a little bit more on a limb and counting on you to perform. Well, the landlord often will, as a part of that, require some sort of a credit enhancement. What's that? Well, it comes in a variety of different shapes and sizes. But typically they'll say, okay, I'll do that, but I need you to increase your security deposit by an appropriate amount. So I'm protected from you defaulting after I forgive your rent for the next 3 months. Or I'm going to require a letter of credit, which is even more beneficial for the landlord because it's protected even if the tenant declares bankruptcy, because it's not the tenant that is owed that money, but the third-party bank. So the landlords love to have a letter of credit, even more so than a security deposit. Or the landlord may say, hey, up to now, we haven't had a personal guarantee on this thing, but now, since I'm going to be coming out of my pocket, in effect, for a chunk of change, I'm going to ask now that the principals of the business or the parent company provide a guarantee, a personal guarantee to stand behind the modified obligations of the tenant. Then the question becomes, okay, what's being guaranteed? Ideally, if a guarantee is required, it's only that additional landlord investment that is being guaranteed, i.e. the 2 or 3 months free rent, or whatever it is that you negotiate. But indeed, a landlord could say, hey, I'll indulge you for a period of time. I'll forgive your rent or give you part rent for the next 6 months, but we're going to need to have you as an individual or the owners of the company or the parent company guarantee the entire lease obligation. So I'm not coming out of pocket and only to get burnt later on. So again, all of these things kind of work together, and the important aspect is to be flexible and creative, in addition to, as we said at the outset, being transparent and coming up with an arrangement that is fair on both sides. Given all of those factors, this is obviously a more complicated process than you might have thought of before. So timing is really imperative. And that's sometimes the stumbling block, is that you've got all these potential complex arrangements to renegotiate, but you need the relief now. So you have to balance that in terms of not coming up with such a complex, convoluted arrangement that it takes months and months to negotiate when you need your rent, forgiven next month. So let's go, if you will, Danny, to the next slide and talk about some of the unique aspects of this. No one size fits all on this. Each component of each negotiation is unique. Each of you tenants are different. You've got different financial situations, you've got different business situations, you've got different needs, and you've got different vulnerabilities. You have to obviously account for those. You're typically, as a tenant, very familiar with those. But it's important to recognize that no two landlords are alike either. They vary all over the map, from super large institutional landlords to mom and pops, who may be actually easier to deal with. And even the institutional landlords can be very different in the way that they approach things. Some have a whole portfolio of properties that is in kind of one big basket. So they've got flexibility to kind of give away some funds on one side of their portfolio and take care of that through balancing things on another side of the portfolio. Others are single asset entities. They'll just have an LLC. The only asset of that particular landlord is that building. So there may be less flexibility there. In almost every case, as I said, it's a multiple party transaction. In addition to the landlord and the tenant, we've already had reference to the property manager. And often the property manager is a kind of a tweener there that can get in the mix. And in fact, the property manager's role can be critical in terms of being an effective communicator or perhaps even a blocker. In some cases, the landlord may be willing to be flexible, but if the property manager is compensated based on the quarterly revenue generated from the project, they may be less forgiving because they're taking money out of their own pockets by facilitating you having a reduction in the rent. So that's yet another player in there. Again, the lender is often an important player because in most commercial landlords, there's a commercial loan behind the project. And an awful lot of times, there's covenants within the loan agreements that actually preclude the landlord from forgiving rent, absent the consent of the lender. So all of a sudden, you've got another mandatory participant in the conversation. And in fact, you may have more than one person or institution in that role, because a lot of loans get shared between lenders. There's co-lender agreements. Oftentimes, there's even another level of lender, a mezzanine lender for a large project. And we've had situations, including for large law firms that I've represented, where we've got the landlord to agree to arrangement, we've gotten the lender to agree to arrangement, but then kind of out of nowhere, the mezzanine lender says, you know what, that doesn't work for reasons that I can't really make clear to you. And then the whole house of cards comes falling down. So you need to consider the lender's role as well. And the landlord is going to be the one that's probably going to let you know about that. Your lease itself needs to be examined very closely, because I have looked at, reviewed literally thousands of commercial leases. And while there's a significant number of common ingredients of those, and I can kind of walk through and kind of recite a table of contents in my mind of those provisions that are going to be in there, there's all sorts of variations on the theme. There's no two that are the same, and you need to look at the specifics of your lease to know what your remedies are and what the ramifications are of defaulting and the like. Similarly, you need to look at a couple different aspects of the market. One is just how kind of firm or soft the market is in your particular area for your particular product type. And so it's really a sub-market by sub-market and product by product type. So retail is going to be different from industrial. Industrial is actually going very strong right now, while the office market is a little softer. Retail is way softer than that. It varies greatly by industry. It also varies greatly by a sub-market. So that's important. And another aspect of the market is something that I've become deeply familiar with here, and that's this very renegotiation concept, because we have seen over the past several months there to be a whole new set of information where I'm favored at CBRE because I've got thousands of colleagues, and so I can share with them and vice versa, really what's working and what's not. And that's how I've kind of become the subject matter expert for renegotiating leases. But your broker can help you figure out really what's working and what's not in the market in terms of actual renegotiation. Be prepared, if you move on to the next slide, Danny, please, if you do ask for a rent forgiveness or restructure, that you're going to have some homework to do. If there's an institutional landlord, you're almost certainly going to be asked for this, and you're going to be, even with more of a mom and pop arrangement, be asked for some variation of this, but it's worth walking through these to kind of prepare yourself. First thing the landlord's likely to want to know is, is it really this COVID situation that has caused your problem, or are you just kind of saying, hey, everybody else is having trouble, I want to get some relief as well here. So they're going to want to demonstrate a rational nexus between the pandemic that's going on and your inability to pay rent. You're going to have to demonstrate a valid reason for your request and actual hardship with the rational nexus to your inability to pay. As we referenced before, they're also likely going to want to know that you have checked out your interruption or your business interruption insurance without success, because they want to be the last resort for solving your temporary economic woes. They don't want to be the first resort. So they're going to want evidence that you've actually pursued that without success. Similarly, they're going to want to know that you have checked out other sources of potential relief. And I'll have at the end of the program here a resource for you. Kind of has all the different small business resources available for different kinds of relief. But again, the landlord's going to want to know that you've checked out all the alternatives before you come knocking on their door. In addition, they're likely to request a significant amount of financial backup and data. They're going to want to have your last couple of years audited financial statements and tax returns to support your argument about your need for the money. And they're also going to likely want your current balance sheet, any year-to-date statements that you have, any projections that you've got about what's going to happen going forward. Because you've got a really fine line to walk here. If you think about it, requesting relief out of hardship is really a double-edged sword. Because from the landlord's perspective, if you come to them and say, hey, my business is on the rocks, I'm gonna just crumble, or I'm gonna go BK if you don't provide me with XYZ relief, the landlord may feel like, well, gosh, this is a really, really risky tenant. So the position that you have to be able to convey is that your problem is temporary, but that you've got a solid business model, and that going forward, if they do accommodate your request, you're going to be in a strong financial position and be able to make up these obligations later that are being forgiven currently. Another question that we get asked a lot, if you'll move forward, please, Danny, is who you want to work with in trying to figure out a structure that makes sense for you. I would think that you certainly do want to get input from your lawyer in terms of understanding the ramifications of your lease, and importantly, understanding the ramifications if you default, which are likely not pretty for you. Commercial leases are largely created by commercial landlords and their lawyers, and it may be eye-opening to find out what your lawyer has to say. A lot of tenants have a little bit of a naive perspective that, hey, there's this thing called the duty to mitigate, that if a tenant defaults, the landlord has to go out and try to backfill that space so they don't have as much damage as they would if they weren't able to get another tenant. But that's really overstated and slightly mischaracterized. The actual law is a little bit more subtle than that, and it really allows the landlord, if the tenant defaults, to get the current present value of the entire income stream for the remainder of the lease term. Even if that's 10 years out, the present value of that lease income stream less what the tenant can demonstrate, the landlord would have been able to mitigate or make up for if it had taken reasonable steps. Well, that's the burden of proof on the tenant. It's a tough burden of proof. And so it's important that you understand the legal ramifications if your consideration is defaulting. I've been asked whether there's kind of consultants that specialize in this. Haven't seen any kind of cottage industry based around this, but these other folks that we itemize here really all do come into play. The closest we see to that kind of consultant are really the accountants and the brokers. You do need to consider your own personal accounting ramifications of this, and it's very helpful to have somebody that can be sensitive to the likely ramifications for the landlord, or at least if the landlord kind of comes up with an explanation or an assertion that they're going to have some accounting ramifications that may throw a kink in the works, someone that can really kind of vet that for you and be your guide on that. Honestly, in all humility, we found that the brokers can be very, very helpful here in terms of their knowledge of the market in your particular submarket and industry and so forth, as well as really what's working and what's not. And hopefully, if you've got a good real estate broker, you've got somebody who's a pretty good negotiator and diplomat to help you work through this. So they often have been a very good interface between the landlord and the tenant. Interestingly, an awful lot of landlords actually want to look their tenant in the eye and talk directly with them. And so what a lot of tenants have found that the landlords really require is that they deal directly with the landlord. Now, that's not without consultation with all these other folks. So you can certainly have all sorts of other background. You can have input from somebody like me, from your attorney, from your accountant, but then sometimes the landlords really want to deal directly with the tenants. Again, everyone's different, so you have to be prepared to interface the way they want. We found more often than not, tenants have asked their broker to take the role of taking the lead in interfacing with the landlord. Let's finish up the substance with the next slide, which is the famous what not to do. We talked a bit about the shortfalls of the legal arguments as a pragmatic matter, as a practical matter. And in conjunction with that, what I have found is often very tempting, and the lawyers are often very tempted to do this when they give you advice, is to send a nastygram, is to send the lawyer letter that says, you know what, if you don't do this because of all these reasons, force majeure and commercial frustration, X, Y, Z, we're going to sue you and we're going to take you down. And we found often that really does more harm than good, because while the lawyers often feel like, well, at least we'll kind of create some reasonable doubt in the landlord's mind and kind of move the playing field a little bit in our favor, often it does more harm than good, and you end up alienating the landlord, and you end up then negotiating from a position of acrimony rather than cooperation. So frankly, we found that more often than not does more harm than good. Another thing that we've seen a lot of tenant representation brokers do is to kind of send form letters. They have a letter that they give to all their tenant clients and say, hey, here, send this in. And they do a mass request for a rent reduction. You know, most landlords weren't born in a barn, and they can smell a form letter when they see it, and they aren't particularly well received. So this really needs to be a personalized, individualized approach. Often the tenants feel like, hey, if I withhold my rent, that'll get their attention. It will. Probably not in a positive way. The landlord will, just like if they get a lawyer letter, they'll probably put that in a whole different pile. They'll respond to it probably through their lawyer in a way that's less advantageous for you. You withhold rent, you're probably just digging a hole for yourself. You'll definitely get the landlord's attention, but you'll also get late fees, you'll get interest, past due interest. Often your lease will provide that will trigger other negative ramifications like a required increase in the security deposit or prepayment of rent on a quarterly basis. There's all sorts of bad ramifications for the tenant from withholding rent. More often than not, we've seen when the tenant uses that as its initial approach, the negotiated result at the end of the day, the best result they get is not having all of those penalties that they just self-inflicted by withholding rent. So they really kind of dig your own hole by withholding rent. You're much better off being proactive, communicative, and pragmatic with the landlord. The last two kind of go hand in hand, and we've seen it a whole bunch. We started the outset, hey, Mr. and Ms. Landlord, things are just so darn bad here. The sky is falling. I'm going to go BK if we don't give me this rent relief. We've talked about the fact that may backfire on you. Just being whiny and difficult is not going to win the day with the landlord. I think you need to be creative, practical, and develop a win-win resolution in conjunction with and cooperation with the landlord. With that, if I'll go to the next slide, I'll offer you some resources. As I mentioned, CBRE is the largest commercial real estate services firm in the world. So we've got a bounty of resources. This weekly take is available that gives you just kind of the latest and greatest of what's happening with the real estate world and how the COVID situation is affecting it. There's this whole playbook on reopening workplaces of a variety of different types, including restaurants, Chris, also office and industrial situations in terms of best practices of distancing and signage and operations and so forth. I mentioned before the financial relief resources, and that is this financial relief hub, which is available for you to check. And it basically just is kind of a list of all the available funds that are out there that might provide relief for you. It never hurts to check on those things. People have had their businesses saved by this PPP money, with maybe more to come. And there's a lot of different variations on that theme that are certainly worth exploring. I do represent a lot of law firms, including my former law firm, Procopio. Just finished up another deal for them today. So there's a special batch of information about law firms. But again, there's a huge amount of information there. And for what it's worth, I'm more than willing to make myself available to consult. Again, our model is to work on behalf of the tenants, where we don't charge the tenant, but the landlord pays our fee. So it's kind of hard to say no to sometimes. And I'm happy to consult with anybody if they want to follow up offline after the fact. With that, we're kind of closing in on the end of the hour. So if we can go to the next slide, we just wanted to open it back up for any feedback, questions, thoughts, or concerns that you might have, and I might provide some input on.
So yeah, Tom, we got a couple of questions drop in. I think I think you did answer them a little bit here, but really what it is what do you do when a landlord is really just not being flexible and is pushing eviction when, as the business owner, you don't have the revenue to pay the rent?
Well, again, you can plead for mercy. It sounds like you've got a pretty unsympathetic landlord there. What you need to do is to provide that quid pro quo, provide something that you can offer that landlord in exchange for that relief you need so badly now. What is that? You know, typically, again, it's some variation of extending the lease term or agreeing to repay that money within a reasonable time and enhance your credit by providing a personal guarantee for that, or providing a letter of credit that will give the landlord security that they'll be repaid. Because again, if they're concerned they're going to go out of business, the last thing they want to do is to essentially loan you money. And so you really need to, this is the creative part where, you know, just playing the fiddle, the violin and giving the skies falling spiel isn't going to cut it, but you really need to kind of put yourself in the landlord's shoes and say, okay, what might make sense that I can provide the landlord that would make sense from their perspective as well. And that's where, you know, your broker and other business consultants can kind of help you. But some of the models that we talked about in this presentation of blend and extend or other variations on that theme are what you need to do, because you just can't expect to get something for nothing.
Yeah. So another one that's similar related, but I think I'll kind of rephrase a little bit, because she's talking about that she's in the service industry. We know that there are some industries that haven't been able to reopen, or, you know, of course we have a lot of tourism, event-based industries here. You know, when there's still that unknown factor, what are some of the suggestions that you could give for these that are still faced with the giant question mark?
Well, it really kind of goes back over the things that we have talked about here. One of the things that you don't want to do is to make promises that you can't keep. And that's what we initially saw kind of in April and May, where a lot of folks said, hey, you know, this is going to be short and sweet. It's a bad situation, but we're going to get through it quickly. If you'll forgive my next 2 months of rent, I'll repay you by the end of the year. Well, you have just then kind of created a bigger hole for yourself. And again, even for folks that are now saying, hey, I'll repay you monthly between now and the end of 2021. Well, gosh, we don't know when this thing is going to straighten out, right? And it could be, we're not many people are talking about a V recovery anymore, you know, and even a Nike swoosh is seemingly a little bit optimistic at this point. It could be a long, drawn out process. And that's why this renegotiation thing isn't, you know, just a flash in the pan, but it could be needed more and more as we get deeper and deeper into people's, you know, abilities to withstand these ongoing hardships financially. But it's pie in the sky if you think you can just walk away from it. And unfortunately, as I said, those legal arguments that we itemized have been tried. And even with, you know, some of the strongest tenants, with some of the most powerful Wall Street lawyers have applied those arguments. And frankly, I've not seen a single one succeed. So you really need, I think, to get your thinking cap on, talk to your consultants and figure out a way to come up with a win-win situation that is workable from the landlord's perspective as well as your own.
Fantastic. So next we've got a couple that are related to funds that they may or may not have received from PPP. One is from your friend Chris here again. What are the best arguments to convince a landlord that they are not entitled to funds received from PPP loans?
That they're not entitled to what, Danny? I'm sorry.
The funds received from PPP. So I got a PPP, and maybe a landlord is saying they're entitled to some of that money.
Well, the landlord's not entitled to it, but if you want to have that PPP loan forgiven, you're required to apply the majority of it to payment of your employees or to rent are the primary factors. So it's fair game for the landlord to ask for it. You're not required to give it to them. There's no direct funnel to the landlord, but you certainly can't argue with a straight face that that's not an appropriate expenditure of a portion of the PPP money. Certainly employees were kind of target number one there, but another express way to apply those PPP loans in order that they be forgiven and become grants is that it go to rent. So I'm afraid that's not going to really be a winner of an argument.
I'm just asking, Tom, though, what would you argue if you were actually trying to preserve all the funds and only use them for payroll?
Well, again, you're going to have to kind of put you in the position of everybody else, in that you're going to have to provide the landlord with something else, and it may be, Chris, that if the landlord forgives you this rent and you don't use that money for rent, that in exchange for that you have a negotiated resolution that if they forgive your 4 months rent, that you'll extend the lease for 18 months at the back end, right? So there's something in it for them, or you provide credit enhancement, or it's kind of, again, it's any combination or permutation of those structural elements that we reviewed.
And then the last one is because there were some entities that weren't eligible for PPPs, in particular 501c6s. So those are like your chambers of commerce, business improvement districts and the like. So any suggestions for them who are still having to pay perhaps rent, but they couldn't get a PPP, what would you suggest there?
Well, they're really in the boat with all the other commercial tenants. I mean, unfortunately, that could be trade industry groups and so forth, and they're really in the same mix with all other commercial tenants. They don't have any special treatment, so they, like everybody else, have to come up with a creative resolution that's going to be providing something for the landlord to motivate the landlord to be flexible and indulge them in some sort of temporary relief.
Well, fantastic. That was our last question, and we hit the hour mark. I really want to thank Tom, for getting on. Of course, with the Small Business Development Center, we've helped, thousands of folks access a lot of the disaster capital, but there's areas of expertise. We always want to bring in fantastic people like Tom to talk about this. I know, we have so many clients that are out there that need this, and many other business owners. And we really want to thank Tom for his time, his invaluable expertise, his wealth of knowledge. And I think we all were able to kind of learn some of these things. And for me, it was nice validation, because day one, I started saying, make sure you just talk to your landlord and communicate. So that's the number one thing we've been preaching since day one. And I think that's what's, more than anything else, is we're all in this together to communicate, be open, and work with everybody. We're all in this together. So again, really appreciate this. Thank you, Tom. And thanks to everybody.
Happy to do it. Please feel free to reach out if you'd like to discuss your own personal situation. I wish everybody luck and success and good health.
And I will be sending out a recording of this to all those who registered. So thank you.
All right. Take care.